Good afternoon, Mr. Brooks.
Good afternoon, Mr. Chair.
Are you well?
Yes, thank you, and you.
Very well. We've had the privilege of interviewing you at least twice before. Would you just want to make a statement in motivation of your application, whatever it is you may wish to say, so that from there we can then put questions to you, rather than take you through the whole long process as if we don't know you?
Right, thank you. Well, yes, thank you. Correctly, I have been twice before, which means the passage of time, and it has been my privilege to be requested during that period of time to act, and I've been based in Mthatha for the majority of that time period, and I've got to know the division from the inside, as it were. And there are a few developments there that I think are factors which need to be taken into account. One of them is that there is a definite increase in the number of medical negligence cases in Mthatha, which is an interesting thing within our bigger division. And they are complex, and they are currently being challenged and are running, to use the local colloquial term. So the civil role in Mthatha is a lot more complicated than many would think. And I think that is an area in which I am able to make an informed contribution.
Thank you, Chief Justice. Mr. Brooks, just two aspects. When you were at the bar, you were involved with pupillage training. For those of the Commission that don't know what that takes, can you explain briefly both the content briefly and the amount of time that it takes?
Yes, thank you. It's a program which is run under the auspices of the General Council of the Bar, the GCB. One has to go and qualify as a pupillage trainer, and there is a method which is utilized in the United Kingdom that we make use of. And the idea is to give pupils a practical education during the year of pupillage. We divide the exercise up into the obvious areas of criminal law, civil, the motion court, and then there's an ethics component. I specialized in ethics and motion court, and it involves hands-on mentorship, one-on-one. It involves following coursework, which is set out and made available through the GCB. It takes quite a lot of time. We have training sessions. There's a fair amount of after-hours involvement. There's a training weekend in which we involve pupils and try and create as live a situation as possible. Some of the judges continue to be involved in that. And we assess them, and we help them to move from the academic approach to the more practical approach. And very loosely speaking, that is pupillage training, advocacy training.
And what remuneration is there for you?
No, there's no remuneration for us.
And then one other aspect, I see you've acted from the third term of 2013, the whole of 2014, the whole of 2015, and up to now in 2016.
Yes.
Do you have any practice left?
Commissioner, as you know, we are not allowed to practice while we are acting. No, I don't have any practice left. But one would hope that if I needed to, I could revive one, but no, I don't have a practice left, in reality.
And being very direct with this commission, there's a significant difference between the income of a silk and the income of a judge, and you've made that sacrifice for quite a long time. I ask you to be frank.
Yes, well, if you want me to be frank, yes, I've made in months when I'm employed as an acting judge, I earn much less than I used to earn as a silk. And as an acting judge, there are significant periods where I earn nothing. So were I to be appointed, I look forward to an increase in income. But it certainly will not be the same as income as a silk. I accept that.
Thank you.
Commissioner Malema.
Thank you very much, Chief Justice. Advocate, do judges take an oath?
Yes, we take an oath.
What does the oath say?
Well, I presume it's the same as the one we take as an acting judge, but we, in basic terms, we promise that we are going to treat all persons alike without fear and favour, and we uphold the Constitution of the Republic of South Africa and do our jobs in accordance with both of those main tenets.
Advocate, you didn't apply to be an acting judge, you applied to be a judge.
Yes.
What does the oath of a judge say?
I've not seen the oath that a judge takes.
So you want to be a judge and take an oath you have not seen?
I'm presuming that it's similar to the one that you take as an acting judge, Commissioner.
So when you act inconsistent with the Constitution as a judge, will you be upholding, defending, and respecting the Constitution?
No, one must act in accordance with the Constitution.
When you act inconsistent with the Constitution, will you be upholding, defending, and respecting the Constitution?
Acting in accordance with it, yes.
Inconsistent with the Constitution?
Inconsistent?
Yes.
No, definitely not.
And when a judge acts inconsistent with the Constitution, does the judge deserve to continue to be a judge?
No, no.
Thank you very much.
Professor Ntlama.
Thank you very much, CJ, and good afternoon, Advocate Brooks.
Good afternoon, Commissioner.
Just two questions. Yes. In the form, on page 8, you made reference to the fact that you don't have any publications in law.
Yes.
And even outside law.
Yes.
Then how would that impact on you as a judge to write judgments?
I don't think that one needs to have a history of publication in the public realm to be able to write a judgment. Obviously, writing judgments takes a bit of practice, but I don't think that it certainly hasn't been something that I'm conscious of that's been to my detriment.
Then the second question is, just to share your opinion with us on the recent judgment of the Constitutional Court on the EFF-DA judgment versus the Speaker, on whether the court has not overstepped its authority and got into the domain of the executive or the legislature.
No, I don't think so. My
Why?
opinion is that it's been a very good, bold, brave restatement of principles which one can loosely term as being indicative of the principles involved in the rule of law. Of course, that's all interwoven with the necessity for separation of powers, and I haven't considered any aspect of it to be an overstatement of what a court would be called upon to state in those circumstances, in appropriate circumstances.
So what does the rule of law encompass?
It's inherited from way back when, and what we really are looking at is to make sure that the exercise of power, particularly executive power, is always subject to the law. It must always be lawful and in accordance, usually and mainly, in accordance with the principles entrenched in the Bill of Rights. Thank you very much.
Commissioner Didiza.
Thank you very much, CJ, and good afternoon.
Good afternoon,
Advocate.
Commissioner.
When you were giving your introductory comments in the beginning, you mentioned what has the span of time empowered you with in terms of the knowledge of certain aspects that you might have not dealt with before. One of the things you've mentioned was how complex civil matters are in Umtata than it is maybe thought of. If you could unpack that a bit, what did you mean?
Well, I come back to the fact that on our civil roll in Umtata Weekly, there are 2, sometimes even 4 matters involving medical negligence, and those are intricate. It involves hearing evidence and becoming competent in adjudicating evidence of a specialist medical nature. Whilst legal principle remains the same, whether one's dealing with negligence in field A or field B, those are intricate matters, and obviously the amounts at stake are enormous. So that is what I had in mind when I mentioned that. For the rest, we are on a par with other seats in the division where there is a healthy proportion of road accident fund matters, commercial matters. But Umtata, and to a lesser extent Bishu, but particularly Umtata, the growth in medical negligence cases is quite marked.
Commissioner Modise.
Thank you, CJ. Good afternoon, Mr. Brooks.
Good afternoon, Commissioner.
In your view, what are the major causes of obstacles to justice in South Africa?
Here, money remains one of them, unfortunately. It's access to justice without money is much, much more difficult than access to justice with money. Resources, education. I think there's a growing awareness daily of legal rights and the availability of justice in situations. But there are many, many, many people out there. I think of violence against and abuse of women and children. There are many out there who are unaware of rights, who have little access to justice. So it's a very complex, multi-fronted set of difficulties.
Okay. Can you talk to us a little bit about your understanding of judicial independence? And can you perhaps give me an idea about how you balance this understanding of judicial independence and the duty of the courts to avoid encroaching on the matters which may be belonging to the other arms of government?
Thank you. Well, we traditionally refer to as the third arm of government. I don't think that one can read any value judgment into that, but the third arm of government is the judiciary. It's there to interpret and to apply the laws. In doing so, one must be careful not to be legislating, which is the job of the legislative, the second arm of government. And obviously one cannot enter into the realm of using executive power, which is the executive's role. And it's very necessary to be independent because one is called upon to interpret and to adjudicate upon the way in which the executive has exercised their powers. And one can't do that if you're not independent, if you are in some way party to, part of, or biased towards, or influenced by either of the other arms of government. And we've had an excellent example of how the separation of powers stands us all in very good stead very recently, and the ability for the judiciary to express itself as an independent judiciary. So it's a self-conscious awareness in the process of being a judge, the maintenance of that independence.
That judicial independence, can it be confused with, let me let me paraphrase that. Is judicial independence and judicial accountability mutually exclusive? Can the two very good concepts be practiced in such a way that me, layman, Jan Alleman, understands that whether the judiciary is feeling independent or not, I am catered for, and who is supposed to hold the judiciary accountable? Is the judiciary self, in your own thinking, does it hold itself accountable? Because there is confusion usually, speaking as a politician, about judicial accountability.
Yes. We may have different views on what that means, but my response would be that within the judicial system, there are the checks and balances that ensure that there is judicial accountability, and by that I mean reviews and appeals, because the way in which the judicial independence finds expression is in the outcome and in the manner in which the judicial officer conducts himself or herself. And if there are difficulties with the outcome or the process, it's either review or appeal process. And then, of course, there is the Office of the Chief Justice, there's the JSC. There are avenues through which approaches can be made by the algemene mens who are aggrieved by any experience within the realm that brings him in contact with a judicial officer. And they believe that there is something for which that judge should be accountable that has not been taken into the reckoning.
CJ, thank you.
Thank you. Commissioner Nokesi.
Thank you, CJ. Advocate Brooks, I understand from my reading that you are sensitive with regard to question of quick delivery of judgments.
Yes, I am. We get into deep trouble if we don't deliver judgments quickly within the system. We are accountable on a termly basis to our judge president in that regard. But I think it's very important. There's a lot of effort that goes into an approach to court. Very often, extremely limited resources are involved, particularly in Mthatha. It's a deeply rural, impoverished region, or surrounding Mthatha. And a lot of the litigants that come there have come there with enormous effort. And I think that one of my first judgments that got sent to the JSC, that unfortunately never saw the light of day because we encountered the reality that what had been advertised wasn't a post until such time as there'd been a restructuring, and we'd got DJPs in position of the old chief justices of the former homelands, Transkei and Ciskei. But that was an early judgment I did in an opposed urgent application, which I'm getting too detailed here, but there were a lot of matters on the Mthatha roll, and that was one that had been overlooked by practitioners, and I only became aware of it the day before it was due to be heard, and I said it shall be heard because there were senior counsel coming from Cape Town and Johannesburg to argue it. And in that judgment, I spoke of the need to accommodate litigants as far as was practically possible, and the importance of the dignity of the court being preserved, and also that I think I used the term that in the Helicon days, immediately after the dawn of our democracy, something of that nature, one of the expectations that litigants justifiably have is that their matters will be dealt with, and will be dealt with efficiently and expeditiously. And in my view, delivering a judgment as quickly as one can is part of that.
And And just an advocate, Brooks, when I look onto these judgments, your judgments, I've not seen an instance where you have reserved a judgment for more than 3 months. Am I correct? I mean,
No, that is correct. Both the occasions I've been here previously, I've had no outstanding judgments. My JP will tell you that I now have one, which I need to work on this recess, but it was reserved, I think, on the 17th of March of this year. It was a long matter, part heard, ran for 2 weeks. That was the second week. It had run a year ago for a week, and then it ran again in that week of March. And it's an enormous matter involving quantum in the hands of a foreign national who was maliciously prosecuted by a commercial company in Mthatha, and he has lodged a claim. And it's an intricate and complex matter, and I have to deal with that judgment. But it's not been outstanding since anything longer than the 17th of March of this year.
my last question, CJ, is this. With regard to, I mean, the JP has asked you this question. I understand your family is in Grahamstown, but I pick up you have at least your children are a little bit old, 27 and 30 years.
Yes.
Look, I mean, in the Mthatha areas, as JP has indicated, a lot of people just go there only to take position. They want
Yes.
to go. What is your commitment that you will remain in Mthatha? What commitment can you show?
I intend to make that commitment. It's a very difficult place in which to find accommodation. I have to mention that immediately. And I do have a spouse who has just as much right as I do to a career. And she has a career in Rhodes University in Grahamstown, and obviously whatever happens to me has an impact upon that. But that said and done, for the last 2 years we have lived with the reality that I am committed to working in Mthatha, and she's committed to being where she is. One doesn't want to make decisions about the future in the absence of any indications to what may or may not be permanent. So that's the way it's been. And initially that's the way it's going to remain if I am put in Mthatha. But we are very open to the prospect that she may join me there on a permanent basis. We're very open to the reality that even if that doesn't happen, I must have a base in Mthatha and I need to be there. So I can give you my commitment to that extent at this stage.
Thank you. Commissioner Ntsebeza?
Thank you, Chief Justice. Mr. Nokisi's question was the question I was going to put.
Thank you.
The Chief Justice has allowed me an indulgence to make a follow-up because I just wanted clarity on a certain point that was raised earlier with you. There is a school of thought, I think it's called the skeptics in jurisprudence, that says that, especially in borderline cases, nobody really knows what the law is until a court of final instance has pronounced on it. Would you agree or disagree with that view?
I think that is the skeptical approach. I think that there is one of the fundamental principles in law is certainty, and in many areas we have certainty. That said and done, there is always a challenge in law, and I remember one of my senior colleagues from the bar who acted many years ago gave good advice, and his advice was, don't ever assume that you know the law as a judge. Always refer to the books. Always refer to decided cases. But very often you are called upon to define a development in the law, a different angle on the law, and indeed to pronounce upon what the law would be as a court of first instance. But that is not always the case. In very many areas we know what the law is and we have to apply it.
I agree with you. And isn't it so therefore, equally, that in such instances, even questions of what is or isn't consistent with the Constitution may elude different judges at different stages of the development of the law?
Mr. Commissioner, we're all human, and we all have different perspectives, and nothing worse than a room full of lawyers having differences of opinion on what something means. And that, I suppose, is what makes our profession so lively and so challenging.
The rest of my questions, I think, speak for themselves. I need not raise them. Thank you.
Thank you.
Thank you, Chief Justice.
So you want to rejoin, Commissioner Malema?
I want to come in.
Yes.
Thank you, CJ, for your indulgence. Counsel, can not knowing the law be an excuse in law?
It depends on your circumstances, said I, the lawyer, back to you, Mr. Commissioner. It depends on the circumstances. If you are meant to know the law, it's no excuse to say that you did not know the law. If you are allowed to be ignorant of the law because of whatever other position you occupy, it can be an excuse.
You are an adult with huge responsibilities. Amongst those responsibilities is to sign off the law. Can that be an excuse of not knowing the law?
No.
Thank you, Commissioners. You are excused.
Thank
Mr.
you very
Brooks.
much. Thank you very much, Chief Justice. I thank the Commission for the courtesy of the interview, and I wish you well in your deliberation.
As he walks out, colleagues. No, you are excused.
Oh, thank you.
As he walks out, after this, it is the Supreme Court of Appeal candidates.